Hi, everybody. This is Arkady Frekhtman, New York City personal injury trial attorney. Happy New Year. And today we have a really interesting show. I'm going to be looking at the Courtroom View Network. And this is information that they have published on YouTube. So you can go to their channel and you can actually watch this yourself. And I'm going to play a few clips. This particular article is entitled Key Elements or Key Moments in 8 of the latest headline-making trials that CBN has covered. And what they do is they cover trials, actual real trials from all over the country. And they go to the courtroom, they have videographers in the courtroom recording these trials. So let's go to the first trial. And this was a trial in Georgia. It was a medical malpractice trial. And it resulted in a $75 million jury verdict. And what happened was, it was in October of 2022. Jurors in Georgia handed down $75 million against a pair of doctors after finding them liable and responsible for what's known as locked-in syndrome, a type of paralysis that happened to a patient. And other medical providers were cleared. And so the plaintiff in this case, his attorney, argued that delays in diagnosing and care of a stroke is what caused this paralysis. And in the closing argument, one of the attorneys, her name was Laura Shamp, she outlined the miscommunication that led to the ultimate injury. So we could actually listen to what they feel, what CBN feels is a key moment in this trial that led to the $75 million result. So let's take a look.
And what I think we learned throughout all, and you guys know all of the evidence, that there was this failure to communicate. Failure to communicate between Dr. Womack and Dr. Futrell when they were on the phone. A failure to communicate between the radiologist and Dr. Womack when there was this critical result that was found. A miscommunication, you'll remember this conversation between Dr. Womack when Dr. Womack, the ER doctor, said that stroke was still on his list of potential causes, but P.A. Nickham said it had been ruled out based on their conversation. And just throughout the trial, this lack of communication between the players. I don't know if it struck you throughout the evidence, but what struck our team was how the conversations that you heard evidence about lasted 1 minute, 2 minutes, 30 seconds. These critical information about literally life-threatening, important information was communicated in seconds when there was a person that everyone acknowledges was very sick. I think every witness who testified said he was very sick. And yet this communication, Dr. Waldschmidt said he had a 30-second phone call about what he described from the stand was potentially a stroke. When he described the finding that he found, he missed several, but even the one he found, he said he communicated in less than 30 seconds. This idea of not taking responsibility for the communication of vital, important information.
Yeah, so I think that was interesting. I mean, what she's obviously arguing is that communication was important, and when somebody goes to a hospital, that's what medical care is for, right? Medical care is to make you better, to diagnose, to find out what's wrong with you, and to get you better. And so the doctors have to communicate with each other, with the nurses, with the hospital, and get you better. And this lack of communication, almost like they don't care, right? Because it's something that's so important, it's your life, and they're choosing not to communicate. But then there was another attorney, and he represented one of the doctors in the case, and this doctor was actually cleared. There was a defensive verdict. So this doctor was found not liable. And CBN felt this was a key moment in the trial for the jurors to find this particular neurologist not liable and clear him of any fault. So we could take a look at what happened here in this case.
We're in this case, folks, for one reason, because this note got changed. That's the only reason we're in this case. Because the Buckaloos would never for 6 months have allowed Peter Futrell to continue to take care of their son. If they thought he was so incompetent that he would ignore information about chiropractic, they would never, I mean, for 6 months he kept coming and seeing their son. If they had known that he bungled a call after being told about a CTA and a chiropractic, what they thought, but he had to be brought into the suit because the records were altered. This is the record they got when they got the medical records to see what happened. So when they got the records say Womack called Futrell about a CTA. That's what they said. That's the one note that was changed, where they talk about the Baser-Arley filling. The second note, and that you've seen it all. I think it's one of these is plaintiff's 13 and one is plaintiff's 14. One shows the native note, one shows the changed note. This was all added the next day after he was tipped off by Mr. Nickham that there was a problem. And then this note is added. They added the CTA. So when they got the native note, and their good lawyers looked at the note and said, wait a minute, Womack called him about the CTA. We've got to include Futrell in the suit, because if not, they're just going to say, well, we called him and he didn't respond. That's why he's in the case, because of this note. If the native notes are there, there's no documentation he was told about CTA. Even when the note was changed, he never added the chiropractic business. Where in this?
Yeah, so that's another interesting point. I guess what he's saying is that they're only there because another doctor, a co-defendant who was liable, changed a medical record. And because of that improper and illegal change to the medical record, now his client got implicated, and the jury believed that and cleared his client. So I hope you found this helpful. This is interesting. And there's a few other cases here. We could do other videos. They have a case where a hospital was cleared in a suit about counterfeit implants. They have a case here with a $27 million medical malpractice verdict over a delayed meningitis diagnosis. This is actually a very interesting case. I watched some of this case. This was in Iowa, and it happened last month in December of 2022, where a jury handed down a $27 million verdict to a man who suffered brain damage following bacterial meningitis. So what happened was he was suffering 103, almost 104 fever. He went to an urgent care. He went to a hospital, and they misdiagnosed him. They said that he had the flu, and they actually thought that he was on drugs instead of giving him the proper standard of care. And it led to this delay. And then Nick Rowley was the trial lawyer. He's actually from Trial Lawyers for Justice. That's one of the groups that I'm in. I've worked with him. I've gone to some of his trial by human webinars, and I've worked with him. Hopefully I could try a case with him one day. He's a really good friend and a good lawyer. So we could watch his closing argument. And this, again, is what CBN felt was a key element in the verdict. And it's a $27 million verdict.
We are here because healthcare providers must think prospectively. Got a patient here, and in fact, Melanie Chews did think prospectively. And you're going to see when she made her prospective choices. She said, you know, of course this patient will have. Go home, come back in 5 to 7 days if it's not any better or if it gets any worse. That's death. She was thinking prospectively, but she wasn't thinking prospectively with the standard of care on that Friday night when everybody was closing up shop. That's what it's all about. It's about thinking, what's going to happen to this patient? What's going to happen to this patient if I let this patient go out with this serious infection? This serious infection, it's bad. This man's in bad shape. And they've acknowledged he couldn't even get up out of he couldn't stand up from the bed, he needed help. You needed to walk him in, to get him out of the car. This man needed help. look at a patient and say, if we don't give them the help they need, if we don't perform that one test and it turns out to be bacterial, then that patient's going to be in a whole lot of trouble if the symptoms are that bad. That patient's going to be in a whole lot of trouble. That patient might die. That patient might end up with brain damage. But look, I can do this and make sure healthcare providers must think prospectively. That didn't happen in the right way here. That is negligence. That is below the standard of care.
Yeah, so I guess what he was saying there is he was talking about what's known as differential diagnosis, right? So when a patient comes to a doctor, they have to have a differential diagnosis and look at the worst possible thing first and rule that out. Once you rule that out, then you go to the next thing. And so here, it was prospective thinking, like what can it be? You have to look to the future prospectively, and you have to rule out, and they did not rule out the bacterial meningitis, which led to the permanent brain injury that this person suffered. So that resulted in a $27 million verdict. And they have a few other cases. They have another med mal case here for $68.6 million in Florida, where a woman received that verdict for a catastrophic brain damage due to a sodium imbalance. And what happened was jurors apportioned liability among critical care doctors who treated her with 98% of the blame to going to two doctors. And her attorney was Michael Trentelange, and he walked jurors through a timeline of her care at the hospital and argued that the evidence showed that the plaintiff's sodium imbalance was negligently overcorrected, and that's what led to the brain damage. So we could take a look at his argument here. This was actually his opening statement, not the closing, but the opening. That's what starts the entire trial. That's one of the first things that you do when the trial starts, once you have the jury in the box.
The evidence will show that a doctor is never allowed to needlessly endanger a patient. That a doctor must communicate with fellow doctors for the well-being of their patients. And that a doctor must know his or her limits, know what you know and know what you don't know, and ask for help. If doctors violate any of these rules and harm a patient, then they're responsible for all the harms they cause. The rules are such that correction of low sodium being dangerous is not supposed to be done too rapidly. It depends on whether the low sodium is what's called chronic or acute. Chronic sodium means that you have a known, I'll say again, a known sodium level that's low, and it's been low for 48 hours or more. That's chronic. You know that to be the case. The other definition is that it's acute hyponatremia, and you have a known sodium level within 48 hours that is low. If you don't know, the rule is that it's chronic until proven otherwise. I'll say again, if you don't know, it's chronic until proven otherwise, because a doctor is never allowed to needlessly endanger a patient. When you have hyponatremia that's been present for a while, the cells in the body, including the brain, will adapt to the low sodium level. They reach osmotic equilibrium. So if the cells have been adapted to that condition for some period of time, then your raising the sodium is much more traumatic. They're much more vulnerable to an osmotic insult when they've expanded and adapted than if they haven't had time to do that yet. That is to say, that if it's acute. So that's why the rule is the case. They violated the rule very, very severely by raising the sodium that much in that period of time.
Yeah, so that's an interesting case. That was the case with, basically what he's saying there, and he's using a template, like there's a famous trial consultant named David Ball, and he has like an outline of how he recommends plaintiffs to do their openings. And I think that lawyer was actually using that template because he says a doctor is never allowed to needlessly endanger a patient. And that's kind of like your rule of the road. You start with that and then you explain, now I'm going to tell you what happened in this case. And he has a whole outline, and that lawyer was following the outline. But look, it works. Those outlines work. That's the reason that, you know, a trial consultant is somebody who spent their whole life at trial, even though they may not be a lawyer. They spent their whole life on trial, analyzing what works, analyzing psychology of jurors, analyzing statistics and what is persuasive. And then they give you certain tools. And then that lawyer used those tools, and he won a huge verdict. So yeah, and then there's a few other cases. I mean, not every case is a huge multi-million-dollar verdict. Here's a case where Walmart won in a slip and fall case. They were cleared of any responsibility for a Florida woman who suffered a fall at Walmart stores. The plaintiff's lawyers argued she slipped on water that accumulated from wet umbrellas brought into the store. However, Walmart's lawyer argued that there was just not enough evidence, and he said there was not any water there. So we could take a quick look and see what the defense lawyers argue and how the defense lawyers present their case in court.
Plaintiff's theory in this case, and what they've spent a lot of time talking, obviously I'm addressing the accident itself, and I'm addressing the issue of whether the store did anything wrong that's been proven by the greater weight of the evidence to cause this accident. Their theory is a theory. I understand it. I'm not going to make light of it, but I want to point out that it's a theory. Here's what it is. It's that there must not have been umbrella bags handed out. They don't have actually evidence that they weren't. They're working backwards from the fact that a couple umbrellas are shown without umbrella bags. So there must not have been umbrella bags handed out. We're going to speculate about what time the different people entered the store that didn't have the umbrella bags as shown in the video at that exact time with relation to when it started raining, which is unknown. And we're going to ask you to speculate and assume that dangerous, dangerous word in a court of law. To assume, well, it must be because they asked or wanted to get an umbrella bag and couldn't get one. Walmart wasn't there handing out umbrella bags. All of those 4 points are assumptions. Put differently, there's no evidence. No evidence whatsoever, apart from the fact that, gee, let's look at a video. There's 2 umbrellas without umbrella bags. Let's make all kinds of assumptions from that. That's not the only point I have to make about the liability case, but I wanted to start out telling you that. I mentioned that because I wanted you to understand what we mean by umbrella theory. But now let's talk about the exact thing this slide shows. It's a very crucial point I would submit to you. After the 2 people that plaintiff's counsel hinges their entire case on that are shown with umbrellas, one of which is open and she's doing something with it, absolutely admittedly no bag, and another one, a guy has it down and let's call him swinging umbrella guy. Those are the 2 people we're talking about. After they walk through there, by my count, and you have the video, you're going to have the video, you're going to be able to look at it. Hopefully you're not sick of it already, and you should look at it. There's, I believe, 8 people that walk over, customers, through this area. No issues whatsoever, no slipping. And I haven't even gotten yet to the size of the spill and the difference between what Mr. Portier talked about. I'm just talking about water in general. No slipping, no looking down at their feet, no going like I'm doing here, like kind of walking around it. None of that, not one person. And you know who else is in that group? I'm not suggesting that the plaintiff walked exactly over the spot where she would later fall, but included in this time frame. So between the 2, let's call them the umbrella people and the accident, included in that 7-minute span, plaintiff and her husband, on their way into the store, walked by this area. They're a few feet away, but they walked by. That's where this discussion with her came up, where Miss Absulu started talking about, Miss Absulu started talking to me when I was asking her about this.
That's funny, the guy almost fell while doing his closing.
He doesn't walk looking down. That's fine. It's not really what I was asking her about. I was merely asking her to acknowledge that there was no water there when she walked by. I guess theoretically I'll say, and even if, well, if there was, she missed it, and that goes towards comparative fault. But that's not really what I'm saying here, folks. There wasn't any water there. There wasn't any water there.
Yeah, so basically he's saying there wasn't any water there, and if there's not any water there, well then there's they did nothing wrong, right? The plaintiff has the burden of proof. The plaintiff has to prove that there was water on the floor, that there was a dangerous condition that the defendant should have known about and should have cleaned up. But if there wasn't any water there, then the defendant couldn't have not have done anything wrong. So they won that case. And here's the final case I'll do today. This was an interesting case. This was a jury in California. They handed down a $33.8 million verdict for a man who was fatally struck with a shovel during an altercation that he had with workers with the city. So this particular man was, he had a little bit of a drug history. He had some issues, and he got into this argument with some workers that were doing construction. And I believe that the city stipulated to liability because the construction workers hit him with the shovel and they killed him. And then this attorney turned down a verdict, an offer actually. I think he turned down an offer that was about $3 million or $3.5 million, pretty significant offer for a wrongful death. But he turned it down and he said, no, I'm going to go to trial, because you got to be fearless. And he ended up getting a $33.8 million verdict. And he talked about the value of a father, the value of the father-daughter relationship, and that it's not dictated by how much money you have. And he's a very good lawyer as well. He's actually, this guy's very cool. He's a DJ and he's also a lawyer. So he goes and he does DJ gigs in like Las Vegas. I think recently he was in Tulum, Mexico, doing DJ sets with thousands of people. He's a really good DJ. You can find him on, I think on Apple Music or Spotify, but he's also a really good attorney and he takes really big cases. He got a $68 million verdict. And then this one was almost 34 million. I met him as well when I went down to Cabo at the trial. It was one of the trial colleges. He was lecturing there, and we chatted. And he actually sent me some of his trial transcripts. And he's very willing to share information. So he's a really cool guy. So let's watch his closing argument and see what he argued.
And in a society where we have $100 million paintings, I just want everyone to remember, essentially 5 Picassos have been taken from these young girls. But something even more valuable than 5 Picassos has been taken. And we're going to together come up with a reasonable dollar amount to reflect what's been taken. But if we really looked at Jose and who he was as a father, I think there was more perfection than there was imperfection. I think that the amount of love, despite the circumstances, that he generated, and the safe space and emotional space and affection and hugs and kisses and encouragement that this man demonstrated to his daughters is unique. It's very unique. And it's something that we need to celebrate with a real verdict, with a dollar amount that reflects what's really important. I'm going to show you pictures of, basketball players that pay hundreds of millions of dollars to put a ball into a net, and planes that we spend billions of dollars on, and paintings, and you heard about some actresses and other people with salacious beginnings, now with billion-dollar empires. But as humans, as real people, as jurors, you now have a chance to tell everyone what real value is. Who's the real superstar to a family? Who's the real Picasso to a family? And if anything has value, it's the value of father's love. That has value more than any other thing. That's, when you think about your life, okay, I guarantee you, every single thing you do at the end of the day is to either get or maintain human connection. That's all that really matters. The way you do your hair, your makeup, the amount of hours you work, everything you're doing is to maintain human connection, because that's life. And there is no closer bond and nothing more beautiful than the human connection between parent and child. And that human connection can be arguing. Sometimes arguing with your child is the beauty of life. Sometimes your kid rolling their eyes at you is the beauty of life. Sometimes not getting along with your father is the beauty of life. That is what makes life worth living. Not a painting, not a B-2 bomber, not an athlete, but the human connection you have with your father. And there are people that live this earth that don't have any connection with their parents, or have a limited connection with their parents. And what you saw in this courtroom was, in every single picture, love beaming and radiating with this family. He had $1 billion smile. He had $1 billion heart. Maybe he didn't have a lot of money. Maybe he didn't have a car. But the law that the court told you covers that. We don't award less money for a man because he wasn't a rich man in his pocketbook. The value of a man, the value of a father, the value of a father-daughter relationship is not dictated by how much money they have. Do you know why? You can't hug a paycheck. You can't kiss a paycheck.
Yeah, so that's a pretty powerful argument, and he talks about like paintings that are worth hundreds of millions of dollars, and talks about life and like who we are as people, and obviously I'll let it speak for itself, but I thought it was a really good argument, and I learned a lot from this lawyer. So yeah, so there's a few other cases in here. There's a Texas jury that returned a $10 million medical malpractice verdict. There's one case up here that's interesting. It's a case where I talked about this one briefly. A hospital was cleared in a bellwether trial about spinal implants. And then there was one case all the way on top that was about NFL players. And what they also cleared them. They said that the NCAA is not responsible for an ex-football player's head injury. Now, we've heard about the lawsuits against the NFL for chronic traumatic encephalopathy, CTE, which is a serious brain injury. And this was similar. This was somebody who played football for the University of Southern California in the 1990s, and he died in 2018. And his wife argued that the NCAA was responsible for his death. But what the defense lawyer argued is that this particular individual had substance abuse and a variety of unrelated medical conditions, unrelated to his football career and to the CTE. And in closing arguments, the defense lawyer laid out 4 points, and he said that these 4 points proved that the NCAA was not liable. And ultimately, the jury agreed and cleared the NCAA. So we could take a quick listen to his closing argument and see what he said.
First, Mr. Gee died from sudden cardiac death brought on by his long-standing and uncontrolled hypertension and acute cocaine toxicity. Nothing the plaintiffs have said this morning, and not one shred of evidence, suggests that low-level CTE, which he was diagnosed with by the BU Center, causes hypertension. No evidence. Second point, this case is about 88 to 92. I'll walk you through the limiting instruction, but the judge even told you there's some reasons you can consider things that happened after 1992, but not relative to whether the NCAA acted reasonably between 1988 and 1992. All of that stuff afterwards can only be considered by you for a special purpose. So I just want to remind you that again, and we'll walk through that. Third, I want to walk you through the NCAA's role, which you heard plaintiffs' counsel denigrate and make fun of. But the fact of the matter is, the schools got together, who existed before the NCAA, and started an association. The NCAA is a sports association. It's not a medical body. Plaintiffs would have you believe we had a higher burden than their own doctors who they brought in here to testify as experts, and the entire medical community